Imagine you're being sued and you think, well, no problem, I've got a good defence and the rule is loser pays winner's costs, so when I do win, I'll get my money back. But then you realise, well, actually, I don't think this claimant is good for the money. So even if I win, I'll be out of pocket. Do I have to throw the towel in now? Or is there something I can do about that? Well, yes, sort of. So let's chat about what we call security for costs. As the name suggests, security for costs means that the claimant has to put up some sort of security to show that actually they will be able to pay an adverse costs order against them. But who can you get them against? You can get them against individuals who do not live in the jurisdiction or are not in a country that's part of the 2005 Hague Convention. Now, that's a Hague Convention that covers countries enforcing each other's judgments. It's not the one saying, you can't use fragmenting ammunition. Also, you can get it against a company, whether it is registered within the jurisdiction or out of the jurisdiction. Because the thing there, of course, limited companies, you can't pierce the corporate veil, and people can bring a claim through a company, even if the company hasn't got any assets. There are a few other situations as well, actually. Even if somebody's in the jurisdiction, if you can show that they have, say, for instance, changed their address after they've issued the claim to make it harder for you to find them, or they've put a false address, or they have indicated that they will dissipate their assets so that you cannot actually recover, they're making it impossible to find them, then these are all grounds for which you can apply for security for costs. So how do you apply and when do you apply? Well, you just apply by a standard application notice, an N244 form, which you can get off the government website. You have to support the application with evidence. So you have to say why, first of all, somebody fits within one of these categories, and also why you think they are not good for the money. If it's a corporate defendant, just go on Companies House and download all their accounts, for instance, and look at that. You can also look at the correspondence, though. It's not uncommon for people to actually say in correspondence, well, I'll just wind the company up anyway, I don't care about the costs, or you'll never find my money, I'll put it beyond reach. You can actually put all that in as evidence, which is another reason to keep your sort of, inter-parties correspondence sort of, as calm and collected and professional as possible. When do you do it? At the earliest opportunity, as soon as you can. You could do it even before filing a defence, because the whole point is you don't want to rack up any costs until you know that they're actually going to be covered. What form of security can you get? Well, anything really. Say, for instance, it's a corporate defendant, you might be able to get personal guarantees against the directors. If it's an individual, it could be a charge over property they hold, or if they have money in a bank account, a certain portion of that could be frozen. So, we estimate this is what the adverse costs might add up to, and you have to leave that amount of money in your bank account. One thing though, you can only get this against a claimant. You can't obviously seek security for costs against a defendant because they don't choose to be sued. This also applies if you put in a counterclaim. So say, for instance, somebody issues a claim, you defend it, and you put in a counterclaim. You can get security for costs against the defence element, but you can't get it against your costs of the counterclaim. So you have to sort of do the maths there. You can also get security for costs against a third party if they have taken an assignment of the claim or they are funding the claim with a view to taking a share of the proceedings if the claim is successful. Also, when it comes to appeals, you can apply for security for costs against the appellant, and that's whether the appellant was originally the claimant or the defendant. What happens if the court finds that, yes, security should be provided, but the claimant is either incapable of doing it or unable to do it? Now, quite often, if a claimant is incapable of doing it, they might look into the circumstances and say, well, actually, this is potentially still quite a decent claim. So even though you're probably not good for the money, we're actually not going to make security for costs. But let's say that they do find, yes, there is a risk here and you should do the following to provide the following security, and you just don't do it. Well, in that case, the claim can be stayed. In other words, well, nothing's happening unless and until you do this. Or they can actually just strike out the claim or give summary judgment on behalf of the defendant. Anyway, so there you go. Like I say, it's a useful thing, this, because especially if you are being sued by somebody through their company and you just realise, you know they don't have any assets. So this is, sometimes this application is money well spent. If you found that useful, as always, please consider clicking the like button. And if you'd like to click the subscribe button, that'd be fantastic. And also consider sharing this.